WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
Yes, it is WDXE, and it's time for Bulletproof Estate Planning with our good friend Stan Pierchoski, Pierchoski Law, over in Pulaski, Tennessee, and live and in person with us right here.
I am, and good morning, Jeff.
Good morning. How are you, buddy?
I'm doing very well.
Good.
Very
Been a
well.
whole week since I've seen you.
It has.
Been a lot going on, and just a busy time for everybody, it seems to be.
Yeah. We stay busy all the time.
Yeah.
So I might even be looking to expand. I know I'm moving my office here this summer. I'm just moving like 2 doors down, but I'm moving because the building I have is associated with the theater.
Yes.
And my plan was always whenever they're ready to use it, I was going to relocate. But it's something that's been in the works.
Now
for
you're
a while.
relocating there on the square as well?
Oh, yeah, 2 doors down.
2 doors down. Okay. All right. Well, very good. When you said 2 doors down, I thought you meant 2 doors down from here, and I'm like, where are you moving from here?
No, where I'm at now. So
Okay.
it's not much of a move, but
Very good.
But and it will. It's something we can do gradually and gracefully. So
Yeah.
I just got to do a little work on the building, but we stay busy all the time. And
Now, did you do the seminar here?
I did.
Yeah,
I did on Saturday.
That's right. This
And
past Saturday.
let me tell you something. I used all your tables
Did you?
and had to put out some chairs without tables.
There you go. So you had a good crowd.
We had a banner crowd. We had 70 people. And
Wow.
That is, usually we're in the neighborhood of anywhere from 30 to 50.
Yeah.
So it was just a great crowd, and they were very interested. They're very captivated. They asked some great questions. We were there for a while to finish up, but and it just tells me people are more and more interested in this knowledge. They want to know what their options are because that's what we talk about.
Sure.
I often say I never have any things where I'm here to talk you into something or talk you out of it.
Right.
I'll let you know what you can pick from.
Right.
And most people have something they want to accomplish.
Sure.
And when you find out that, but they don't know what to do. Let me tell you, I think I mentioned this on WKSR yesterday. Was that I get this question a lot, but it seems in the last week or two I got it about three times, and it was I'll use a phone call that I think I got Monday or Tuesday this week for an example. Somebody called me and they said, "Hey, a friend of mine went to one of your seminars. So this gentleman's never been to the seminar. I don't think he didn't hear me on any of the radio stations and stuff. Went to the seminar and said, you talk about this. He said, my dad's in long-term care. And before he would let me even get a word in, and I don't mean this the way it sounds, I'm just saying, before he could even let me get a word, he said, my dad's in care and it's costing this. And he said, I know I waited too late and I know there's nothing we can do about it. And, they're just going to get it all. I just thought I'd make this call anyway, just in hope against hope. And I know we just screwed everything up. We're just out of luck. There's just nothing we can do. Okay, and so, and of course I tell them, well, let's not throw in the towel too early. There's options, okay? But before I even get to there, I hear somebody tell me that, like I said, it was a couple of calls last week and the week before like that, and I get those all throughout the year. But so I think about that, and what that tells me is he's done some looking. I mean, when you have a problem like that, and because it was, when you say that, it's kind of emotional. He's worried, and it's definitely emotional because he's thinking, we're just SOL. There's nothing we can do about it. And so they've done some looking, and they've not been able to find any information, or the information they found was that gloom and doom. The information said, you're screwed. Forget about it. Just fork it over and be done with it, or something. Or whatever you find. But for him to say all that to me before I even, I commend him for making the call because he could have just said, there's no reason to even call somebody. There's nothing can be done.
Yeah.
But I think internally, whether conscious or not, he thought there might be some hope somewhere, and he thought it was worth at least making the call. So, but to get to that point, he's either searched and got misinformation or didn't find any information at all that supports his. Now, he may not know whether the information he got was wrong, but it certainly sounded like the information he got was gloomy. Yeah. And so that got him to that spot.
Yeah.
And so that's why I have the seminars. I mean, if I want to try and distill why I do this, it's that. It's to help people get educated on some of this stuff because when you try to find the answers to it, it's not out there. Or if it's something out there, it's incomplete at best, and it's just plain old wrong at worst. Okay, I mean, it just you're not getting good information. Now, when people come to these seminars, I'm telling you, when I'm talking, I can hear a pin drop while I'm talking. I mean, everybody's riveted to what I have to say because they're all hearing stuff like they never heard. Yes. Or they're hearing things that are giving them hope. Because I'm not there to say I'm there giving you hope. I'm telling you, I'm giving you options that you never heard of, and you start to get a lot of hope because it's like, You mean there's really some solution I can do that can make this situation financially easier? And the answer is yes. You just hadn't heard about it yet. So when you hear it, they perk up and stuff. And again, it's, I'm not the one giving the hope. I'm just giving the education of the rules that we're allowed to follow and the things that you can do. Now, why are they not publicized? I don't have a good answer to that. I think the main answer why you can't find this is it's complicated. So for somebody to put it down on the internet and give you good information, they'd have to spend a lot of time understanding it, knowing it. Okay, it's complicated. And so I think the other thing is nobody wants to go past that barrier of what everybody thinks they already know.
Sure.
And I'm not afraid to do that. I mean, I've always thought outside the box, and I always thought I was kind of, I'll pat myself on the back for it. I think I'm pretty good at it too. But to me, every now and then I get somebody that says, "Well, I don't know how that can be. I never heard of it." And so my response is, just because you haven't heard of it doesn't mean it can't be.
That's right.
It just means you hadn't heard of it.
That's right.
So let's have an open mind and let's listen to it. If you don't want to do it, don't do it. But certainly have the open mind and listen to it. Yeah. But there are solutions to these problems. You hadn't heard of them. You don't know they're out there. When you hear them, sometimes they are a little bit of odd logic, but it's logic nonetheless, and things to do. So a perfect example is got a client that is in long-term care, and it's a special kind of long-term care. It's bad enough to be in long-term care, right?
Yes.
But if you need a special kind, in other words, you have to be in like a memory unit with a lockdown or something because you like to get up and walk away or stuff like that. Those are a little farther and fewer between, And so they found one that they like, but the facility is not a TennCare facility. They're private. And so we only have so many such funds. There's only so much water in the well, so to speak. So we've got to shift the burden to the state, which is what you're supposed to do when you go into care. But the problem we run into right away is TennCare doesn't pay for you to be in a private facility. They will pay for you to be in a facility that contracts with them under what we call Tennessee choices. And if they do, then they'll pay. So now you're faced with the decision. Either we move them so we can get them eligible, or we have to private pay, which is kind of a rough choice. So anyway, I'm working on something there, and I've come up with a few workarounds, but they're not the holy grail. It's more like a stall technique to keep them there for as long as we can until we find the facility we want. But there's certain things that got to get underway, and so I'm working on that. So but to do that, you got to think a little bit outside the box, utilize the rules, or tack the rules together so that it works. So. But again, the whole reason I do these seminars, and that's why I think they were so well attended, is that when people hear that there is a solution to this, there is not what I've heard the whole time I think about this, or maybe mom and dad had to go in a nursing home, and it didn't have to be that way when they were there. Yes. Maybe there's something different we can do, and they want to know. Yeah. And I really tip my hat to the folks that take the time to actually come, because you hear about it, you think about it, and you actually get up and come out here on this Saturday morning and sit, and the presentation was about an hour and 15 minutes long, and they listen to it, and then they stick around and ask questions. I mean, that's the part I can't do for you. I can't make you come to the seminar. I try to make it as easy, as it can be. I often say, there's no obligation. I'm not here. It's not like we lock you in a room and you got to sign something before you leave. I mean, it's just not like that. And you can ask LB. He came to one, him and his wife. So.
Yes.
But it's not like that at all. But I can't get you to come to it. But the people that actually do, they are taking a very important step. Because once you do that and you start finding out there's things you can do, then the ball's going to start rolling. Because I've said before, why do people procrastinate? Really, because they're not sure what to do. Yeah. If you're looking at a truck and there's three of them and you love them all and you just don't know which one it is, you keep procrastinating the purchase because I just can't make up my mind. I don't know what to do. If I pick one, I'm going to feel like I'm not happy with my choice. And that's why people procrastinate about estate planning. They want to do it. They know they need to do it. They know it would be better if they do it. They just think, well, I don't know if this is going to solve this problem. Is this going to fix that? I don't know. So I don't know if I want to just pull the trigger on that. And same thing. So learn. And as you learn, then the decision becomes clearer and it becomes easier and easier to make. So even if that decision is to do nothing, right? At least it's an informed decision. So
we're talking estate plans. We're talking wills and trust. This is the world in which we're talking about. And I had this thought, Stan. You and I have talked, and I guess from the time that I've been talking to you, I kind of know the answer to this. But just for the sake of our audience and stuff, and people that may be tuning in for the first or second time or something like that. The thought hit me, how could I ask this in such a way? Because, and that is, why do we even need to do this? If someone says, why should I even worry about this? Why do I even need this? And I'm like, well, I kind of know because I've been listening to you for a while. I understand that, but to the average person out there who's not thinking about that, I'm thinking, well, they think, well, I don't really need that. That's not for me. Why would I need that?
Well, I can give several reasons, but before I launch off into that, I just want to remind folks that this is an interactive show. We want to give them the telephone number to call. If you want to call in, it's 766-9393. You got two out here, 762 and 766.
Yeah,
766-9393. Call and ask a question or share an experience. Last week we had somebody that just shared an experience.
Yeah, absolutely.
That's great. It helps other people. Okay?
That's right, it does.
And, you can be anonymous or we can make the facts you give me or the question generic. There's no problem with that.
Absolutely.
But it's other people are in the same boat, whatever you have the question for. But, and I talk about this in my seminar a little bit. Why would you want to do it? Well, when you say, why would I want to do it? Let's talk about what it is. It can be just regular foundational planning where you're concerned about where your stuff goes.
Yes.
Okay? Or you're concerned about who's going to take care of my family if something happens to me.
Right.
Or you're concerned about if something happens to me and I can't make my own decisions, meaning I'm still alive, who's going to take care of me or make sure I have the quality of life that I want? Okay.
Yes.
So the foundational planning we do deals with that. We do a trust. It controls where your stuff goes at death, and you can be conditional and put all kind of, these are things you can't do with a will and through probate. But in a trust, you can put conditions on it. If you got a child that blows money like water, you can put controls in there that it gets his money a certain way or over time, or somebody else is in charge of it to make sure he doesn't just blow it on stuff. Or if you don't care, if you say, you know what, I'm going to give it to him, and if he blows it, it's on him, you can just give it to him. Now, I don't like that solution, but I get the logic that some people have.
Sure.
Can't take care of him forever, but there's a way to protect him from himself if you want to do that too. Or if you got people that just can't handle money, like somebody's got a bad drug addiction or alcohol problem, or just a spendthrift, or you got some of you worried about if they get divorced, I don't want their divorcing spouse to take it all. There's all kind of protections we can build in. So those are reasons why I might want to do it. You think about, because let's face it, if you do estate planning, you're not, other than this long-term care that I haven't got to yet, you really don't do it for you. You do it for the people you love, because so they don't have to go through all this stuff.
Right.
And they don't have to fight over who gets what. You've already decided who gets what. It's your stuff. You need to be the one that decides who gets. I'm not a big fan of, I'm just going to let my kids decide what they want. I don't know that that's the best decision. Depends on there's a lot of dynamics in that. It's my stuff. Personally, here's the way I look at it. It's my stuff. I had spent my lifetime accumulating it and building it and breaking my bones and cutting my skin, dealing with it. I got all the sweat equity they call in everything that I own. And I want to be the one that decides where it goes. I'm going to divvy it up, okay? That's just my right, and I'm claiming it, okay?
Yeah.
I'm not just going to leave it to them, because if you leave it to them, you're inviting conflict. Now, I know what they want. If they were going to pick, I pretty much know what they would probably pick.
Sure.
But I'm going to do the picking, because I don't want to invite that conflict. If I leave it up to them,
Yeah.
if there's conflict, what's the solution? I'm not here to intervene. And so I'm going to decide what it is. Now, I will leave certain discretions in there that, if I leave this to all of them, like if you leave them a third each of everything, well, I'll leave certain discretion for them to decide exactly what a third means.
Yeah.
Somebody might say, well, I want these two trucks. Okay, well, that's worth this and this. Therefore, the other two get the same value of other stuff to equal it out. So we're deciding what's in our third. But so some discretion. But somebody's going to control it, and it's going to do what I say. So that's one reason you might do it. How your property goes, who's going to take care of your family. If you have an untimely death and you got a wife and children, or especially minor children, if something happens to you, that's a thought that keeps people up in the middle of the night. If something happens to me, what's going to happen to my family? And so you want them to be taken care of.
Yeah.
Incapacity planning is another reason. If I stroke out and can't make decisions, I want a trusted family member, a loved family member there who knows what I want making those decisions, not somebody the court picks, some attorney that's going to just pick it and doesn't know me.
That leads me to another question. So what if in this scenario happens, but can you describe what happens if somebody has done nothing, has done no planning, no will, no nothing?
You know who asked me this very question was Ed.
Just done nothing.
Well, it's probably not the best situation, but if you do nothing at all, I mean, let's think of it fundamentally. I mean, your stuff has to go somewhere.
Yes.
You're deceased, you can't really keep it anymore.
Yeah.
But it's still titled to you. It's still yours.
Yeah.
So it has to go somewhere. So if you don't have a will, the state of Tennessee writes one for you. God bless them. Always looking out for us, aren't
Bless their hearts.
And it's called the laws of intestate succession, and it gets worse. I mean, they've already decided who your heirs are and what percentages they get. It's kind of straightforward, but it's usually not the way people want it to go. Here's an example. If you pass away, you have 3 kids, right?
I do.
Okay, I do too. I thought you told me that before. But you have
Yes.
a wife and you have 3 children. If something happened to you tomorrow,
Yes.
if you had a will, or maybe you have a will, but if you have a will, I'm willing to bet it says something like, if something happens to me, everything goes to my wife. However, if my spouse
Yeah.
predeceases me, then I want it divided up among the children. Something along those
Something
lines.
along those
Or
lines.
that's typical.
Yeah, that's typical.
Now, if something happens to you and you have a will, that's pretty much what will happen. But if you don't, the question was, what if you don't do anything? So don't do anything means you don't have a will.
Right.
You haven't really discussed anything with anybody. You just have stuff and you pass away, right?
Yes.
Now the laws of intestation you still have to go through probate because the Tennessee state writes the will for you.
Yes.
The laws of intestate succession. So it's a strange word, but if you pass away with a will, you pass away testate, and if you pass away without a will, you pass away intestate. So intestate laws come into play, and they say that first they look to see if you have a surviving spouse, and you do.
Yes.
In this scenario.
Yeah.
And so they'll say, okay, your surviving spouse gets a third or up to a child share. Strange language, and the only time it would be anything more than a third would be as if you only had one child, and then it would be a half. So I don't know why they don't just say that, but they don't. One third or up to a child share. You have 3 children, so she's always going to get a third. So she gets a third of everything, and your 3 children split the other 2/3. Now, that's probably not what you had in mind because the typical will doesn't say that.
Yes.
Okay. Now, that's cumbersome because you have a surviving spouse, and you want her to have everything.
Yes.
Because if you were still here, the 2 of you would have everything. You don't want
That's
that
correct.
division at this point in time. But maybe if you pass away, you're in advanced years, your kids are on their 30s and 40s, grown, have their own lives. Maybe the impact of that is not so difficult.
Right.
But now, I mean, you had a child here a couple times when we first started. You have
Yeah.
a couple of young ones
Still
and
at
minors,
home.
and minors. Well, now they get 2/3. They split 2/3 of your property. So what's a third of 2/3? Going to be 2 nights, right? Each.
Yeah.
And so, but the ones that are minor can't get it because they're minors. You're not allowed to own property. I mean, minors would argue with me about that, but legally, you're not allowed to own property. So we have to, it's not, you don't have a will, so the probate court would appoint a financial guardian over the property until they're the age of majority. And since you didn't have anything saying when they get it, which is ridiculous to let an 18-year-old get an inheritance. But since you didn't say anything, that like in my trust where I say underage beneficiaries don't get it till they're age 25.
Right.
They get it at 18, which is not the best time in my opinion, at least not these days.
Doesn't seem to be, no.
And so, that's what happens if you don't do anything at all. It's decided for you.
Which answers the question why you should do
That is
something.
another reason why you should, because now you have some input.
Yes.
And it can almost anger you because it's my stuff. I spent my life getting it.
Yeah.
I worked for it, or my wife and I, give everybody credit.
Yeah.
But it was us. It was us that did it. Surely we have the right to give it to whoever we want. And you do, but we have to
You
memorialize
have to plan for it.
Because once you're gone, woulda, shoulda, coulda. You can't bring people
Right.
in and say, oh, he told me he wanted me to get everything. That's inadmissible in court. Why?
It won't stand up.
I mean, if I'm the attorney there, I'm going to say, wait a minute, that's inadmissible because I can't cross on it.
Yeah.
It's you saying it. It's hearsay. And we have a thing called the dead man statute. The dead man statute says that anything that deceased said during life that has anything to do with the size of his estate, which is going to be everything you want to bring in, right?
Yeah.
That is inadmissible under the dead man statute because it's unfair to the side, the proponent of the estate, because they can't cross-examine the person. I mean, that's what makes our adversarial system work. You bring a witness in, they can say whatever they want, but they're subject to cross-examination. And that's when, they sit down and you get these witnesses that are pretty flippant, and they say, yeah, I saw him, that's the guy.
Yes.
I saw him take this, or I saw him crash into the car. Yeah, my eyesight's perfect, and I was in a perfect vantage point, and I just happened to be standing there waiting for an accident, and there it was. I saw every bit of it. Then the cross-examining comes in.
Yeah.
And that is not a fun day when that happens. I used to be very good at it.
Yeah.
And by the time I was done,
He didn't see what he thought he
the
saw.
person leave the courtroom with his tail tucked between his legs, because that's the system. Because when you go through direct and then cross-examination, the theory is what comes out is the truth, the real truth. Okay?
Sure.
Now, when you can't cross-examine, you got what somebody says the deceased said. A lot of people feel like they can just come in and say that, and that's not the way it works. It does not work that way at all. So that's why it's so important that if you memorialize this during life, now you have spoken. And now if you're in a trial or after, in a probate contest, now what the deceased said is memorialized, and that is admissible because it's not hearsay. It is a statement that this person made contractually.
Yes.
And it can come in. Okay, there's another word. It's an exception to the hearsay rule, but it can come in. And now you have to rebut what that person actually wanted. Now, if you do nothing, there's nothing to come in, right?
Right.
We don't know what you had in mind. Sure, you can get your wife up there and your kids say, "Yeah, Daddy always said, that we get to keep the farm or we get to keep this car." But first of all, you won't be able to say that. Second of all, if you did, it's just you saying it, and that's unfortunate. So,
and it may be 100% true, but it still doesn't count.
Now there may be a situation, and this is what Ed asked. This is what Ed asked. What if you sit down and talk to your kids and your wife, and you tell them exactly what you want, where you want it to go, how you want it done, and let's say Ed said, let's say they have it's crystal clear to them what you want.
Yes.
You had discussion. They listened. There's no ambiguity between what you said and what they understood.
Correct. Okay?
Then what? I said, well, it is possible in that situation that it could go smoothly. You're right. It's possible because they know and understand. In my opinion, very unlikely. And the second thing, in my opinion, is why take the chance? If you want to do that, let's memorialize it and make sure it's enforceable now. And now, if something comes up, we know. So what could come up? He asked that question. Well, if everybody knows and understands, what could change that? Well, how about a child that knows and understands perfectly the way you want to divide property?
Yeah.
And then get married, or already are married.
Yeah.
The person they're married to says, you know what? Your dad's not really leaving that equal. Because let's say equal is what you think it is. It doesn't have to be a third, a third, a third.
Yeah.
Suppose one of your children ends up being very successful, does very well, pretty wealthy themselves, but one of them is just always just getting by. It just happens, And so when you write a will, you might think, you know what, the one needs a little more because he tries, bless his heart, but he just kind of gets by. And the other one really just doesn't need it. He's got a lot of money. He doesn't need more on top of it. Yeah. So I'm going to leave a heavier share to the one that needs it. Now, is that equal? Well, it is in your eyes, maybe not mathematically, but in your eyes, that's an equitable way to distribute property, in my opinion. So, and that's okay. But if that happens, now maybe the wife of somebody saying, you know what, you got 3 kids, you're not getting a third. I think you ought to get that third because we could do this with it, we could do that with it. And next thing you know, now the child that was perfectly clear is in a rock and a hard spot. He's between dad telling him what he wanted and a spouse interjecting. Now he's thinking, I want to do what dad wants, but I also want to make sure my marriage stays together. I don't want to get divorced over this. You know what I mean? So now things start to waver. So
it gets complicated.
Life gets in the way. And these variables that you can't control, like in-laws and creditors and stuff, other things can happen. It's like, suppose the child is in business and they get themselves in some financial issues. Creditors, we got some issues. And they need the money now. You know what I mean? There's all these things.
Things can get complicated.
My crystal ball is not any better than anybody else's. And so we have to, when we think about this stuff, it could be anything that surfaces.
Yeah.
But so the goal is if we memorialize it, we can literally eliminate all that. Now, they may want to do that, and they may get mad if they can't, but at least it'll be what you want.
Right.
So those are great reasons to do it. Now, if you want to extrapolate into this concept of long-term care. So if you're worried about long-term care and the reasons why should I bother planning in case I go into long-term care, like our asset protection trust or some of the 10 care strategies that we use, well, the answer to that is just because the private pay is just catastrophically expensive.
Yes, it
is.
And
it changes all the time. Since COVID, the prices have gone up twice.
Really?
Now they're up, like $305 or $306 a day is about the average, which translates into about $9,000 a month. And that just happened around I want to say October timeframe this year. But and the facilities do it, but when they do it, they kind of all do it.
Yeah.
Kind of this wave, they all do it. Now they're talking about doing it again. So
Really?
Whenever it is, it doesn't matter. It's going to go up. It's just, there's never going down. It's always going to go up. And so if it's that expensive, you can think about what you're worth, and you can determine that there's a finite amount of resources, right?
Yeah.
Not to mention the fact that, wait a minute, if I don't want all the resources to pay for my care, because if it does, then there's nothing left for my family.
Yeah.
So I want to take care, again, now we're going back to one of the things we said before, what's going to happen to my family if something happens to me? The something that can happen to you is long-term care. Now, when you're older, your kids are grown up, and most people that go into long-term care, and we're talking 65 and older long-term care, and those folks, their family's pretty much grown up and stuff like that, but they still want some inheritance to go to them.
Sure.
Now, if long-term care intervenes, it's very likely, let's say you have a will, you wrote down there you want everybody to get this and get that, and you may be a little specific on some stuff. If long-term care enters into the picture, there may be nothing there for the will to pass.
Well,
I mean, you got to
certainly true.
The will passes property at death, but you got to read a little more into that, and that is it passes the property you have at death. When we talk
Correct.
about long-term care planning, we're dealing with your creditors during your lifetime, and the biggest creditor that's ever going to come up in your lifetime is long-term care.
Yes.
So if there's anything left at death, which is what testament means, last will and testament means at death, if you have that property to give, you can give it. But the real risk is if it's even there. So another thing, so when we do that kind of planning, we also want to invoke what's available to us. We have these spousal impoverishment rules where we can keep money with the spouse. So
yes,
if you go into the nursing home or a long-term facility for $9,000 a month, you're a black hole of expense. Now, I don't mean that to be unsympathetic, but I'm just saying you're a black hole of cost, and your spouse is worried. What happens when it's all gone? How do I live?
Right.
Well, we've invoked these spousal impoverishment rules, the legislature has, and lets us keep a fair amount of money with the spouse so they have a standard of living that they're used to, and that's critical. That's absolutely Now, one of the problems is if you don't do anything, and you go into the nursing and you go into the facility, they're going to want paid. Okay?
Yeah.
I don't fault them.
Sure.
I don't fault them for that. Don't take me the wrong way. And I'm not talking about the care. I'm talking about just paying.
Right.
I'm sure the care is wonderful.
Yeah. Well, it's a business, and they must be paid.
Well, that's right. And of course, you can't survive if they don't.
Sure.
The program would collapse if they don't. Right. So they have to be paid, but they will want payment for as long as you're there. Now, if that starts to invade the spouse's share, that's not the nursing home's concern, nor is there anything they can do about that.
Yeah.
That has to be planned for.
Yes.
And you plan for it by invoking the rule when you deal with TennCare. And you say, okay, I have this much money, I'm taking this much, and we're giving it to the spouse so that they, under the spousal impoverishment rules, and so that they have something to live off of. And they recognize that. But if you're going to stay in a private pay facility, they're going to want private pay. They are not going to, and I don't mean this to be that they're unfeeling necessarily, but they are not going to question where's it coming from.
Yeah.
They want paid. And if you don't pay them, they have the right to eject, and they will.
Yeah.
But where it comes from is kind of behind the scenes to them. Right? It's kind of like if you get your roof fixed and they say it's going to be a $20,000 bill, they don't care if you're raiding your mad money to get it or you're cashing in a bond to pay. I mean, they want their $20,000, right?
Sure.
So that's the same thing. They don't know where it's coming from, and it could very well be coming from the pot that's going to have to take care of the spouse. And so you can exhaust all your money, including the stuff that should be going to the spouse, if you just stay in this private pay scenario.
Yeah.
And then now when you get there, now you will qualify for TennCare. But the problem is now that's all you have left, which is nothing. And so
everything's depleted.
Now we got a real problem. Now it's a real problem. The money is gone. Now who's going to take care of the spouse? Because we've spent it all on the institutionalized spouse. That does not have to happen. And when I say stuff like that, that's what gets people to come to the seminars and hear, because that gets your attention. That does not have to happen. I don't care who you talk to. Joe down the street, or Bob across the street. Bob's always got the inside line. He knows he knows how things work, right? He's got it all figured out. And you go to Bob, and he says, "Man, you need to do this. You need to do that," and it's always not right. It's always incorrect. And why people act on it, I don't know, but they do, or they certainly shouldn't. But anyway, those are kind of things, and those are involved examples. But that's why we plan. We want things to go smoothly for our family. And for these other things during life, like incapacity or long-term care, we want it to go smooth for us. And we want to mitigate the impact of a $9,000 a month cost. Because if you can, I don't know how long you can withstand that rate of financial bleeding, but get your calculator out, and there's an end in sight. Now, if there's not, and you have that kind of wherewithal, private paying could be an option. Because then you go where you want and you get the care you want. It still costs you, but you're in a position to afford it. Okay, so it just those are all perfect reasons, and a lot of those reasons can be very scary.
Let me see if I can describe a scenario for you to deal with. Let's say that the husband and wife, husband has to go into long-term care.
We always put the husband in.
We put him in first. Yes, absolutely. So the husband's in long-term care, and the wife is at home, and they have a home. Okay, they own their real estate. Let's say a house and lot. That's all there is. And let's say he's done everything else right, but no. Let's say that the TennCare is taking over and paying, but she still has her home. Okay, but while he's still living, she sells that home.
Okay.
Then what happens?
All right. Well, let's talk about that. What we're talking about is what is referred to as the primary residence.
Yes, primary residence.
PR, we call it. Now, that's a special piece of real estate.
It is.
Because everything else is called other real estate.
Right.
Primary residence. And interesting enough, and I may have mentioned this before, but it has a certain amount, it's treated differently, let me put it that way. Other real estate is an asset, just like whatever it's worth is like that much money in the bank.
Right.
Other real estate's available for the cost of care. Now, the primary residence is available for cost of care, but it is treated differently.
Yes.
Now, just while I'm thinking about it, before I forget, this might be interesting to you in your business, is that the primary residence has a interesting definition. It is where you live, okay?
Yes.
Which would be that house and the lot it's on, right?
Right.
And any contiguous property, meaning there's no third property owner in between this parcel you own and the next parcel you own.
Okay.
So if you have a family farm that has over the years, hey, Joe sold 50 acres over here, my granddaddy bought it, and then somebody else bought the 150 over here, and they bought it, and it's all touching each other.
They're all touching each other.
And now you got a 1,000-acre farm.
But they're different
if
parcels.
If it's contiguous, that's the primary residence. So now the whole 1,000-acre farm falls into this special treatment.
Okay. That's good to know.
Isn't that cool? Isn't that cool?
Very good
It
to
is
know.
cool. I have put 1,000 acres. That's why I use that example.
Yes.
A 1,000-acre farm. I managed to put it in there as a personal. Now, here's the way it's treated. It is a countable asset. It's considered available for cost of care. But because it's a primary residence, they will exempt it. Now, exempt is a strange legal term. It doesn't mean it goes away. It means we're giving you permission to take it out of the countable asset column, and we'll put it in the exempt column.
Yes.
It's still countable. And you hear people talk about being exempt from tax. Here's a good example. When you're exempt from a tax, they've assessed it, and you owe it.
Yep.
They're just not going to make you pay it.
Yeah.
There's the difference between the two.
Yes.
Exempt means no, there's no tax. Well, no
Doesn't
tax
mean
means
there's
there's
no
no
tax.
tax.
Yeah.
Exempt means there's a tax, you owe it. The exemption is we're forgiving you from paying it. Okay, there's a big difference between the two. So the property is exempt, which means you take it out of the countable assets. It's still countable, but it's exempted countable.
Yes.
Now, what that means is they're going to figure out, when you apply for long-term care, you have to become eligible.
Yes.
And there's an eligibility analysis, right?
Right.
And they look at all what you own.
Right.
Well, that's not in the equation now. They've exempted it. So when they figure out your eligibility, they're not going to factor in your $300,000 house.
Right.
Because let's think about it. You would never qualify. If you have a $300,000 home, which is a countable asset, and everybody's heard you got to have less than $2,000 of countable assets, right?
Right.
And of course, I get on my soapbox when I hear that because that's a category of asset. That does not mean $2,000 to your name.
Yeah.
It means what it says, $2,000 of countable assets.
Right.
So if you got a $300,000 home that's a countable asset, how the heck are you ever going to qualify? Because you've automatically got $298,000 too many. Do you not?
That's right.
Well, they let you exempt the primary residence. And so they take that out of the countable assets. It's still countable, but the exemption is there giving you permission to not consider it. So now they do the eligibility. We've just lowered our countable assets by $300,000. They're not going to use it against us for eligibility purposes.
Right.
So now maybe the husband qualifies, okay? So he goes into the nursing home. Now, that was out of the equation, okay? Now, what happens is at his death, they will exercise TennCare Estate Recovery Act. Now, think about this. Now, I'll talk about the spouse here in just a second, but at death, in the state of Tennessee, if you have any ownership in real estate at death, and right of survivorship which is how most husband and wife own in Tennessee, is an interest in real estate at death. If you do, it triggers 10-Care Estate Recovery Act, which means they come after whatever's in your estate to get back their cost of care. Now, remember the house. It is still there. You still own it. They just didn't use it for eligibility purposes, right? Now, what they'll do, they'll come after it in estate recovery. However, they won't come after it if you have a spouse still living there. I mean, God bless them. They will wait till your spouse dies after you're dead, they'll wait till your spouse dies before they'll go after the house. But they will come after it. A couple more exceptions, like if you have a child under 21 still living there, they'll wait till then.
Yes.
And if you have somebody that's blind or disabled, stuff like that. There's some exceptions, but they're kind of narrow.
Right.
But they will come after it, and they do. And it can be years later. But they will come after it because that is something they can recover from. Now, they don't sell the house and get to keep it all. They can force the sale of the house, and they're entitled to their cost of care.
Yes.
And so they have an itemized list of what they paid. So, if they got $200,000 bill that they say that the estate owes them, and they have a $300,000 home, well, they can force the sale of it, and they have to give the $100,000 left over to whoever was supposed to get the house in the will or under because they only get their cost of care. But and when they do come in, you may have a will that says, "Hey, I leave my house to my 3 kids." Well, the state of Tennessee has a priority claim on the estate because they're the state of Tennessee.
Right.
And if they don't get a priority claim and can't recover, the program will collapse because they have to be paid. Right.
Right.
So the house will be lost under the circumstance you're talking about eventually. Now, whether it's at the first death or the second death, it will be lost. It depends on whether the first death is the institutionalized or.
So, if I'm understanding this right, though, if she sells the house before he is deceased.
Oh, I hadn't got to that part. That's
okay.
Okay.
Then what happens?
All right. Now he's in care.
Yes.
He's qualified. I'm assuming because we exempted the home. That's the only way he could have qualified. She's living in the house.
Yes.
Okay. Now, if she sells it, it is a joint sale.
Yes.
Okay. Now, if she sells it, it's a sale. And now here's the problem you have. The house, the $300,000 house is exempt.
Yep.
When you sell it and get $300,000 cash, the money is not.
The money's not exempt.
So now he is instantly disqualified unless we do something with that money. And there's things we can do with it because we do that often. But before we do that, here's the smarter thing to do. Let me just throw this out here. And when I do this, I'm not giving legal advice, so don't go do this. This is just a Reader's Digest version of how it works.
Yeah.
We often do this. We exempt the home because that takes all that money out of the eligibility equation, right?
Yes.
Now we get them qualified.
Yes.
Now he's qualified, or they're approved. After they're approved, well, then we'll have the institutionalized spouse sign over, quit claim all their right, title, and interest in that property to the spouse. You can do that.
Okay.
The spouse and impoverishment rule, you can do that. Now, once you do that, when he passes away, he doesn't have an interest in real estate. It takes that out of his death, out of estate recovery.
Again, it's planning.
Now it belongs to the spouse, the healthy spouse at home. Now, when it belongs to the healthy spouse, she can do whatever she wants because when we give stuff away and they penalize us, it's not just you; it's you and your spouse. You are a unit to them, and so if spouse gives stuff away and you're the one going in a nursing home, you're going to suffer a penalty period because of what your spouse did.
Yeah,
you are considered. There is no mine and yours. When you go into 10-Care, it's all ours.
Okay.
Now, after we get somebody qualified, now it becomes his and hers, and there is no ours. Is the way I like to plan it.
Right.
And now we deed the house to the wife. It all belongs to her. She can do whatever she wants. She'll have the money. The husband can't have a bunch of money.
That's right.
He's in care.
Right.
If he has too much money, he doesn't qualify to be in care. So we save the house. We have to save it by giving it all to the spouse, which is what the person in care would want anyway, or at least 99% of the time. So, like I said, don't run out and do that because there's more to it than that. I mean, it's a transfer you do, but you have to do it correctly and under the right rules.
You need to seek proper legal counsel to do this kind of thing.
But I mean, you may hear that and think, I never heard of that before.
Yes.
You mean you can save the house? Yes, you can save the house. Sure. There's rule, and this is not what I call First Pierchoski 14. This is not my chapter and verse. Okay.
Yeah.
I don't make this stuff up. I'm not that smart. I follow the rules that are available to us, and this is available for us to do. It is a accepted strategy. It's undergone scrutiny. the courts have said, sure. I mean, the rules say that's okay to do.
Yeah.
I mean, if the rules say you can do it. Now, if the rules right, wrong, or indifferent, if the rules going to change, I don't change the rules either. I change, the legislature changes the rules, not me. If they change it, then I'm bound by those rules. If they take things away, then they're not available anymore. Just like they did in 2006 when we adopted the Deficit Reduction Act. A lot of cool planning tools went away. And that'll probably happen again someday. But, that's the name of the game. It reminds me, we were saying something earlier. You remember when when President Trump was running back in 2016?
Yes.
He always made the comment that, hey, I deal with the rules.
Yes.
And the rules say I can save this much money on taxes if my business is here or does that.
Sure.
I think he called them loopholes. I wouldn't call them loopholes. They're what the rule says.
That's what the
There's
rules
no such
are.
thing as a loophole. The rule says what it says. If there's a way that it work to your advantage, a loophole implies doing something you're not supposed to do.
Well, that's the media trying to put a spin on it, really.
But anyway, he said, who better to fix this than somebody who has so much experience with these rules that let people not have to pay a bunch of taxes on this and that. And it's like, well, people would say, well, but you didn't pay tax on it, so that's not a good thing. I said, wait a minute, I didn't pay tax, but I followed the rules.
Follow the rules. That's
Now,
right.
if we want people not, if we want these corporations and wealthy people not paying taxes, we got to change the rules. And who better to do that than somebody who knows how they work? So I'm just using that as an example, saying, there are rules to this game. Now, sometimes I call it a full contact sport because when we were in the eligibility in 10-care and we're dealing with 10-care, it is a full contact sport.
Yes.
But these eligibility rules are exactly that. They're rules. So is there a way to make the rules work in your favor? And the answer is absolutely. I have done some pretty amazing things. I've even amazed some of the 10-care workers who didn't understand what I did. And once I explain it to them, they say, yeah, I see how that's exactly right. That's how that works. I mean, you can be somewhat creative, but still, we never get out of their sandbox. We're always playing in their sandbox because it's their rules.
That's
I don't do anything that and the whole thing is when we do an application and stuff like that, full disclosure. Not only do I do it, I explain to them exactly what I did.
Yep.
And that works in my favor because I back them into a corner. I say, here's what we did. Here's why we did it. Here's the authority that says we can do it.
Yep.
So you have no other choice but approve because the rules are 100% in our favor.
Yeah, it's like anything, sports, games, all of those things have rules.
Yep.
And you have to have certain abilities to do it, but you also are better if you know the rules very, very well.
Now, let me give you an example because this is one I was kind of proud of. I had to think about it for a while, and those are the things I love. You say, "Here, I'm going to give you a scenario." I love that. Give me a set of facts. And let me chomp on it and come up with something.
Good deal.
We had I talk. This is another long-term care eligibility issue,
Right.
And have 2 children. Okay, and Mom had given the 2 children, and one of them was a disabled child, and what we call a documented disability, which is typically either SSI or SSDI. Well, when you have that, you can give property to that disabled child and not suffer a penalty.
Okay.
You remember I always say if you give something away, man, you trigger this 5-year look-back rule, and they're going to penalize you because you gave something away for less than market value. And the presumption is if you gave it away in the last 60 months or 5 years, you did it to artificially impoverish yourself, right?
Yes.
Okay, and that's usually why people do it. But you get punished for that. You've heard me talk about that quite a bit.
Right.
Now, but there's 2 exceptions to that rule. One is you can give it to a spouse. Okay.
Yep.
No penalty.
Right.
You can deed it from you to the spouse, which is why we deed the property after approval to the spouse. Okay?
Yes.
There's no penalty. And so so you can deed property to a spouse and no penalty. You can also deed property to a disabled child with no penalty. Okay. So now this person, we had them all eligible, but something surfaced that in the last 5 years, she had given each child some money. I think it was in the neighborhood of $10,000 each.
Yeah.
And I'm looking down and say, okay, if it was $500 or $1,000, they probably, certain things are de minimis that don't get their attention. But $10,000 is going to get their attention. Okay, so we're thinking, okay, that's going to, now, I'm thinking, okay, the stuff that went to the disabled child is not going to cause a problem because you can do that without a penalty.
Right.
But the other child was not. So we got a $10,000 gift, which is going to trigger a penalty period. Now, the penalty period would have been short, about a month and a half.
Right.
But it was a penalty period. And we didn't have much in the estate to have the private pay for a year and a half.
Sure.
Because she only had her home and she had given the money away, right?
Yeah.
And we couldn't get it back, couldn't get the money back. So I'm thinking, okay, how do we live with this penalty? How can we make this work in our advantage? Things aren't looking very good. Because they're like, how are we going to pay for this penalty period? It's going to be like a month and a half at $9,000 a month.
Yeah.
You're looking at $12,000, $15,000, right?
Right.
How are we going to do this? Well, in Tennessee, it's one of the few states where you can cure a penalty period. So if you give something away, let's say you gave the person $10,000. Now the person goes into the nursing home and they say, hey, we're going to impose a penalty period because you gave away $10,000. And you go back, hey, listen, man, they're giving me a penalty period. Can you give me the $10,000 back? And let's just suppose the person you gave it to says, sure, here, I don't want it to be hardship for you. Here's your $10,000 back.
Yep.
Well, now the penalty period has gone away because now we have the asset.
Yep.
When you give the asset away, they punish you because they say if you had the asset, you could pay us. But now you have the asset back. Okay, so you can cure the penalty period. So I thought, all right, let's play this out. How about I come up with a way where there's no impact? I mean, so far it sounds like pretty glim. There's not much we can do. We gifted it to we gifted it to the other child that was not disabled. They don't have it. They just blew it. You know what I mean? They don't have it to give back.
Sure.
They kind of wanted to, but they said they haven't got anything. They barely could make the rent anyway, which is kind of why she gave them the money in the first place. But but they couldn't pay it back, so we can't cure it. Okay. So I'm thinking, okay, what do we do? What do we do? How do we fix this? I thought, okay, there's a way. They have zero impact. Why don't we do this now? Stay with me because this is fully in square within the rules, right? We're going to take the disabled child, okay, and she's going to give her brother $10,000. Okay, now that has nothing to do with mom qualifying. It's two individuals that they're not the applicant, right? I mean,
right.
But you know, if they wanted us to disclose it, I'd be more than happy to do it. But she's going to give him $10,000. Okay, so think about it.
Got it.
Pretty good. Now this disabled son's going to give his mom $10,000 and say, "Mom, here's the $10,000 you gave me. I'm giving it back."
Yeah.
That cures the penalty. We don't have a penalty anymore. But now mom has $10,000, which is too much, right?
Right.
So now mom has a right to distribute property to a disabled child at no penalty. So she turns around and gives it to the daughter. No penalty. The daughter got her $10,000 back. The daughter's made whole. The son's not out a dime. And now the end result, no money has been gained or lost. But the penalty period has gone away. Now, that day, get this.
Okay.
We submitted that, and I got a phone call, and they had a question about that. Can you imagine that?
Can you imagine? Yes.
And I said, great. You got a few minutes? Let me tell you how it worked. Okay.
Yeah.
Daughter gave the son $10,000. Okay, I'm not going to rely on any kind of rule on that, but other than she's allowed to gift property to anybody she wants.
That's correct.
It's her property; she can do it. And when she gave it to him, ownership was complete. If you want to see where he deposited in his bank account, we'll show you that. And ownership is complete; it belongs to the son now. I said, "Yeah, I agree with that." I said, "Okay." The son said, "You know what, Mom? You gave me $10,000 about 2 years ago, and that triggered this penalty period. So I'm going to give you $10,000 back." And the question, but she's given the daughter's money. I said, no, ownership was complete. They're giving his money.
That's
and
right.
Said, okay, I got it. That's right. I give that to mom back. And now the penalty period's cure, and I cite the statute that says if you get it back, we actually can do a partial cure or a complete cure. This was a complete cure.
Yeah.
Mom got the $10,000 back. So, okay, I get it. The penalty period no longer exists, is what the caseworker said.
Yeah.
And I said, that's right. I said, okay, but she said, okay, now she has the $10,000. Okay, so now mom can give property away. People say, oh, I don't want to give it away, the 5-year rule.
Yeah.
You can give it away. It's just consequences.
Right. You got to know.
You can give it away all day long. There's no prohibition to giving it away. The problem is if you give it away, you get this penalty period that goes with it.
Yeah.
That's the baggage. But you can give it away. There's nothing says you can't. So she says, okay, now she's going to give it to the disabled child. And here's the rule that says the exception is that you can give to a spouse or a disabled child, you can give property with no penalty.
Yeah.
And that's what she did with the $10,000. So now, you don't, in all reality, you don't really need to look at the daughter and the children because that's outside your jurisdiction. But if you want to see the full picture, that's what happened. And the end result was that they said, well, I'm going to have to think about this a little while, but it looks like everything's okay. And it's like, well, you think about it all you want. Everything is okay.
Yeah.
But you think about it as long as you want. And, I said, I think you'll find it fits squarely within the rules. And you know me, because it was somebody I've dealt with before. I said, if we get a denial on this, we will be talking about it at a fair hearing. And if you don't understand it, I'm confident the judge will.
Yeah.
Because you know me, I cite the rules.
Yeah.
You follow the trail, and if you find a way it doesn't work, then you raise the issue. But
In
you
this
won't
scenario,
find it. It's not there.
In this scenario, though, the caseworker wouldn't even have to know where the son got the $10,000.
They wouldn't have to, but if I explain it, it makes it clear what we
Sure.
did, and makes it fit in the rules better. So the
Yeah.
question is, can you make the rules work in your advantage? And the answer is,
Yeah.
usually. I'm not going to say all the time, but usually, or at least mitigate and make
Yeah.
it better. That was a complete fix. I thought it was pretty cool.
what I've come away from this with this conversation and many others with you is that there's usually a way to make whatever circumstance you're in better.
Or there's always something you can do about it.
Yeah.
There's, it's not like these calls I get where I've never had a situation where there's no option.
Yeah.
Sometimes limited, but never no. There's never too late to do it.
Yeah.
So,
yeah.
hey, by the clock behind you, I see we're getting
We got
close.
a couple of minutes.
But
Yeah, we are.
Funny how it goes so fast. But
You need to remind folks where you are and all that.
Yeah, I'm over on the square in Pulaski, 103 North First Street. Pierchoski State Law, Pierchoski Elder Law. You can call me and talk to me about any of these topics at 931-363-7222 or go to my website, which is estateplanstand.com. And you can see my phone number there. You can send your question by email.
Yeah.
Or you can see my calendar, and you will see that the next seminar I'm doing is March the 16th, and we're doing that over at the Star Theater right there, right next to my building on the square in Pulaski. That's a Saturday. That's at 10 o'clock. It's going to be the same thing we did here last Saturday. It's called Will's Trust in the Nursing Home, and that's a big venue too. So if we get a good attendance, we should be able to house everybody.
Does that start at 10?
10 o'clock on Saturdays, yeah. And
And you had a great. I was glad to hear you had a big crowd here this last one.
I mean, they filled your parking lot and overflowed into
That's great.
into the other ones. So
That's great.
So there's that. So if you need to talk to me about any of this stuff, by all means,
Absolutely.
feel free to do so. And the seminar, what I'm going to do about these seminars, I think I mentioned to you, is we're throttling back on those. So after this March one, they're going to be probably half as many throughout the year.
Yep.
So come to them if you want. So
There we go. Check out estateplanstand.com. That would be a good thing to do. Pierchoski Estate Planning. And we appreciate you being. We'll see you next time, brother.
always a pleasure, Jeff. Thank you.
Thank you, man.
Communications.
Punishing Russia even more. I'm Dave Anthony, Fox News. The day before we mark the 2-year anniversary of the Ukraine invasion, President Biden in a statement says Russian leader Vladimir Putin will pay an even steeper